Now I'm going to deal a little bit with the substance of non-apparent disabilities in the workplace from a legal standpoint. Keep in mind, how many people here are in Washington State? Okay, so that's pretty much everyone. Washington State has its own law. Andy Imperato knows nothing about it. Okay, so I'm talking about the federal law, but keep in mind that you have a state law that's different than the federal law, and there are people in this room who know a lot about it. So if there are questions about it, I'm going to refer to people in the room who know about it, but I don't want to ignore it, because the reality is that the state law in many states is much better. I'm talking about it from a disability standpoint. It's much better than the federal law. So if I'm a disability advocate, I'm going to use the state law, and if I'm an employee with a disability, I'm going to assert my rights under the state law. So I just encourage folks to recognize Andy's talking federal, but keep in the back of your mind there's also state laws, and in some cases local laws that deal with disability rights and deal with the definition of disability in a different way. So the ADA definition of disability has 3 prongs. It comes from the Rehabilitation Act, and those 3 prongs are a person with a disability is an individual with a physical or mental impairment that substantially limits a major life activity, an individual with a history of such an impairment, or an individual who is perceived or regarded as having such an impairment. When Congress said physical or mental impairment that substantially limits a major life activity, by substantially limits, they meant prevented or severely restricted in doing a major life activity. And by major life activity, Congress meant activities that are of central importance to most people's daily lives. So they invented a new standard that wasn't in the statute, and they applied that standard. This was a unanimous decision. They applied that standard to Ella Williams, the woman with carpal tunnel syndrome, and they said, well, you know, she can brush her teeth, she can clean her house, so even though wiping down cars may be hard for her, there's a lot of other stuff she can do, and if she was really disabled, she wouldn't be able to do any of that. So they said she's not disabled. I can't think of a case that's a better example of judicial activism. I also can't think of a case that's a better example of my principle that we do not have one consistent champion for disability rights on the United States Supreme Court. There are 9 justices on the United States Supreme Court. All 9 of them got it horribly wrong in Toyota versus Williams. So every time there are new people appointed, and by the way, I should point out, that case came down before Chief Justice Roberts and before Justice Alito. So 7 of the 9 who were involved in that case got it horribly wrong. Alito and Roberts were not involved. But we need a champion on the Supreme Court, and we don't have one right now. Maybe Roberts or Alito will evolve into it. Hard to say. But I'm hopeful that whoever the next president is, we can actually get somebody on the court who really understands disability rights, because I would argue right now there's no evidence that any of the 9 people who are currently on the court do. So the Toyota case made it even harder for people to come into the protected class, because you get a case like Kerry McClure in Texas, who testified in support of a bill that's going to overturn all these decisions. And you know, he's a guy with muscular dystrophy, okay, who had been hired to be an electrician, and he was at the end of the process where he had to pass a health exam, and during the health exam the doctor said, can you lift your arms above your head? And he said no, because that's one of his issues with disability. And the doctor said, well, how are you going to do your job as an electrician? And he said, I'll use a ladder. You know, that's what I've been doing all this time. They used the fact that he couldn't lift his arms above his head to revoke the job offer. He challenged it under the ADA, and he lost in the appellate court on the issue of whether he had a physical or mental impairment that substantially limited major life activity. With muscular dystrophy, he's not disabled enough. And they used the fact that he had worked his whole life, that he could have sex with his wife, and that he could brush his teeth to say that, well, clearly he's not disabled. Okay? So this is the kind of analysis that we're getting from the courts. And again, why do we have a civil rights law for people with disabilities? Because people experience unfair discrimination that has nothing to do with their disability. That's why we have a civil rights law. But now they're saying, unless you are really messed up, you're not disabled, you know. And that is so not the point of the ADA. So it's been very frustrating. The other case that I love talking about is the Littleton case. Littleton versus Walmart. This is a guy Charles Littleton, who has an intellectual disability, somebody who Ben Stiller would call a retard, okay? Somebody with an intellectual disability who is on Social Security disability insurance, okay? And he is trying to bring a job coach with him to an interview with Walmart. Walmart refuses to allow him to bring the job coach to the interview. I'm just repeating the facts of the case. I'm not trying to beat up on Walmart. But they refuse to bring the job coach to the interview. And he challenges that under the ADA. And the court says, you, Charles Littleton, on Social Security disability insurance with an intellectual disability, you are not substantially limited in major life activity. And we're not really convinced that thinking is a major life activity. So that's where we are